couldn't complete our discussion on that. So we will be do some recap on last week discussion and continue where we finished. Unfinished. So we started discussing about what does it mean by commercial conveyancing and what type of problem our clients usually faces when they do the commercial conveyancing. We have explained that commercial leases and then commercial buyings, these are usually falls under the commercial conveyancing. And we at Avista Solicitors provide this type of support and services to the clients. And Mr. Shushanta Saha, he usually looks after this section. He is the principal of Avista Solicitors and has got a vast experience in this sector. So even today we will have discussion with him. So Mr. Shaha, welcome to today's session. And
Thank you,
again,
Jagdeep.
apologies to our viewers for last week's disruption. So if we start with our discussion on commercial conveyancing, we were discussing so far I can remember schedule of condition. What does it mean and why it is so important in a commercial conveyancing? So, if I can remember properly, you were discussing why a schedule of condition is important. So, if you can continue on that point, so our viewers can relate from the last week's
Okay,
session.
thank you, Jagdeep. It's very important topic. It is basically say both parties, landlord
Mhm,
as well as the tenant.
mhm,
Neither party can demand that, especially the landlord cannot demand from the tenant that this has to be done before you leave the premises.
mhm,
Nor tenant has any duty to repair in such a way that which he hasn't received at the beginning of the tenure. So it is
mhm.
for the both parties satisfaction and peace of mind, just to avoid any kind of dispute. We always encourage, you know, landlord as well as the tenant to have a schedule of condition.
All right. Who bears the cost of schedule of condition usually?
Is depends, is both party, end of the day, the term how they, reach an amicable
Mhm,
settlement. Sometimes landlord will say it is your responsibility, you are taking my premises, you got to bear the full cost. Sometimes
mhm.
tenant is saying no, it is for your best interest, you should bear the cost. But most of the time we have seen that usually it bears 50-50 by both parties.
All right, got it. Uh, you have mentioned that schedule of condition is required because there are repair obligation at the end of the lease. So that's where the dilapidation claims comes as well. So what's the relationship between dilapidation claims, repair obligation, and then the schedule of condition? How does it protect the interest of the landlord as well as the tenant?
Okay, very good question. Usually, we always encourage our, especially the client who are tenant, not for the
Hmm.
landlord. We always encourage that please consult with a solicitor before you enter into any kind of negotiation with the terms and conditions of the lease.
Hmm.
That is the main point. Sometimes you will see that the tenants, push you so much that please go ahead. I am happy with the terms and conditions. Don't delay. I need to start the business, this and that. But
Hmm.
I do not encourage it. I personally always encourage, please understand the terms and conditions. What is your legal and financial, obligations? So the question, I'm coming to answer to the question you have raised, that how it is linked.
Hmm.
Landlord, at the end of the tenure, may will raise a big list of dilapidation that you need to fix these issues before you leave the premises.
Hmm.
To avoid any kind of dispute and the litigation, it is for tenants' best interest to have a clear picture what is his responsibility in respect of repairs.
Mm-hmm.
What his or her duties to bear the cost. If it is
All right.
clearly defined in the lease that neither party can just show off that you have to do this, do that. No, it is clearly defined in the lease that this is my responsibility in respect of the repairs obligations. You cannot expect anything more than that. That's why
All
it is
right.
very important.
So it's like looking at the future after the end of the term, what will happen. So yes, that's correct. I mean, that's one very important part of the lease we are talking about, that schedule of condition. Usually we have seen the clients are not aware of it, and we always ask the client whether you want a schedule of condition or not. And
Mm,
when we explain to them, only then they understand. And we have seen recently that most of our clients are opting for the schedule of condition, and that's a very good thing for everyone because it helps at the end of the day and it reduces disputes between the landlord and the tenant.
very true, very
So,
true.
yeah, thank you so much for that one. So, next thing we want to look into or put some light into is that sometimes people tax lease for like 20 years or 25 years, 15 years, but they do not want to continue after probably 5 years or 10 years. So, what option they have in those scenarios?
In the scenario, most common practice is the break clause.
Mm-hmm,
If parties agree during the negotiations that there is a risk I may will not be able to continue for the 15 years or 10 years. If
mm-hmm,
there is a risk, they can enter into negotiation that break clause. Both party can enter into a negotiation that after certain period of time, either party will give the notice to the other party. Usually normal practice is they give 6 months notice
mm-hmm,
that I'm terminating the lease on such and such a date and time, and they can get away with it. But without the break clause, neither party can, you know, do that. It is equally important for the landlord as well as the tenant. Landlord may will need the premises, after 5 years, even though they
mm-hmm.
are offering that I'm, giving you the 10 years lease, but he may need the premises for himself to run the business or do something else.
All
So
right.
just to avoid the litigation and the unnecessary cost and hassle, they should have the break clause. Simultaneously or similarly, the tenant have a protection as well to have the break clause. If there is a
All right.
risk, just to avoid the risk, they should have a break clause that after certain period of time, giving the notice to the landlord, I will quit.
Okay. So on the other hand, we have seen sometimes that the clients want to continue their business even after the end of the lease. And they always ask question, is my lease inside or outside the 1954 Act? Sometimes we call security of tenancy. Some
Mm,
clients are aware of it who are like regular business clients who have got previous experience, but who are like a newcomer who are just starting their business. Sometimes they don't know about it. And when we act for the tenants, in most cases, we see that either the provision is there or not. I mean, we explain to the tenants definitely in our report, but for the viewers, what can you describe in this regard? I mean,
okay.
how the security
Ve-
of tenancy impacts.
Okay, it is again very important topic, Jaydev. You have noticed on many occasions, especially these messages for the new business, whoever is thinking to start the business,
Hmm.
don't have any kind of idea that what could be the terms and conditions of the lease. This is very
Hmm.
important topic. We always inform from the beginning. That's why I always encourage any tenant, before you enter into negotiation with the landlord, consult with a solicitor
Hmm.
who can inform them or advise them that what is the benefit to keep the lease inside the act, or we call is open lease, or it is whether he prefers to keep it close, that it is a fixed term for 10 years. I don't want to keep the business open. As you know that in a business tenant, they have a right under the act that end of the tenure he can request the landlord for
Mm-hmm.
automatic renewal. It's not his discretion, it's not landlord discretion. If it is within the 1954 act, he can request for automatic renewal, and landlord cannot deny it unless there is a gross breach of the terms or failure to uh, uh, rent areas or any dispute like that. If there is no such disputes, he or she got to accept the automatic renewal. But if it is outside, and if the business flourish, end of the tenure, tenants approach to the landlord, I want to stay further 10 years. Landlord is bound to give the renewal of the tenancy. So that's why it is very, very important for the new business owner, before they start the business, to understand the terms and conditions of the lease, especially whether it is a open lease or a closed lease.
All right. So yeah, that was very, very resourceful. Another thing I want to touch it, I believe that's the last one, is the rent review. I mean, the clients usually agree a rent at the start, but after 5 years, usually, the rent review comes. So, do you deal with it, or does anyone else deal with it? How the client can handle this?
Okay. This is another very good topic for every tenant, not the only the newcomer, even the established business owner. They got to know as well that
Mm-hmm.
usually rent review as per the lease, sometimes it is 3 years, 4 years, or 5 years. Rent review is always, you will see that is terms of the condition, it will refer that it will be always high end, means that no matter how the market is volatile or not,
Mm-hmm.
if you agree that the rent will be reassessed after 3 years, and it will go high regardless of the current market value of the
Mm-hmm.
premises, it will go high if it is referred in the lease. So it is very, very important, especially for the tenant, that how they agree whether rent review will be assessed at the end of 3 year, 4 year, or 5 years. Most of the commercial leases usually, if both parties agree, usually it takes place every after 5 years.
All right. So yes, thank you. Thank you for your thoughtful and very experienced discussion. So I believe the viewers will be benefited from this discussion. And definitely, if you've got any question regarding lease, or if you're planning to start a business, you can definitely discuss with Avista Solicitors. And our email ID and the phone numbers are given at the bottom of the description. And thank you, Mr. Shah, for joining us today, and thank you, everyone.
Thank you for having me. Thank you, Jaidev. You have a